It begins with a scheme straight out of a low-budget thriller, luring a victim with the promise of sex, only to set them up for a violent robbery. In the courtroom today is Tony Reddy, the young woman at the center of this dangerous plot. She's facing a no-nonsense judge who has read every line of the evidence and can smell an excuse from a mile away. But just when you think you've heard it all, the case takes a shocking turn during a follow-up hearing, revealing a drug test with faint lines for cocaine and a web of questionable associations. Then, in a stunning contrast, a second defendant steps up. He's a man asking for a second chance, and his story of redemption is so powerful, it might just bring the court to a standstill. Two defendants, two very different paths. One spirals deeper into trouble, while the other fights for their freedom. This is what happens when your past comes back with a backstory.
17D, State of Texas versus Tony Renee Schiaretti. Can I have parties announced for the record for the state?
Ryan Groomer for the state of Texas.
For the defense? I'm sorry, I have to turn on the fan. It is so hot in here. And are you Tony Schiaretti?
Yes, ma'am.
Ms. Schiaretti, I'm going to show you what's entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions. Did you review that document with your attorney? Did you understand it? Did you electronically sign it in all the appropriate places?
Yes, Your Honor.
Did you understand the state is proceeding on the lesser included offense of robbery? That's a second-degree felony. The range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. Did you understand?
Yes, Your
Did you
Honor.
understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court to find you guilty, not grant you community supervision, and sentence you up to 20 years in prison and up to a $10,000 fine? Did you understand?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses to this offense?
She has.
Will find that defendant has knowingly and voluntarily waived her right to jury trial. Showing you the plea bargain page. Did you review that page with your attorney and did you understand it?
Yes, Your Honor.
According to the plea bargain agreement, the state is proceeding on the lesser included offense of robbery. There's a $1,500 fine. State recommends deferred adjudication. Did you understand that to be the plea bargain agreement?
Yes, Your Honor.
Defense is at the plea bargain agreement.
It is, Your Honor.
State is at the plea bargain agreement.
It is,
Next,
Judge.
I'm showing you outside the plea bargain agreement. The state is requesting that your deferred adjudication be for a term of 5 years. There'll be a TAP evaluation, community service hours, no contact with the following persons: Kerry, Kerry, Yadel, Yelldel, Terrence Smith, Michaela, Makayla, Guerra, Ezekiel Washington, Arthur Wallace, that's AURTHUR, and you are enrolled and obtain a GED and maintain employment. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, Your Honor.
Then to the lesser included offense of robbery, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence to support.
The plea is in no contest. This is a crucial move. It's not an admission of guilt, but it allows the court to proceed with sentencing as if she were guilty. The defendant, Tony Reddy, is accepting a plea for deferred adjudication. Think of it as a contract with the court. If she successfully completes her probation term, in this case 5 years, the charge can eventually be dismissed. But if she messes up, the judge can find her guilty and sentence her to the maximum penalty of 20 years in prison. The plea bargain is on the table, the legal technicalities are done, but now comes the real test. The judge is about to put down her papers and ask a very simple but devastatingly direct question: what are you doing with your life? The answer she gives will set the tone for this entire hearing, and you can already feel the tension ratchet up.
The defendant's plea?
Yes, Judge. State would offer State's Exhibit number 1 to the court. No, Judge.
Court will accept into evidence State's Exhibits 1 and attachments and will be the same. All right, after viewing State's Exhibits 1 and attachments, the court will find there's sufficient evidence.
That was the first test, and she failed spectacularly. Her immediate response wasn't remorse or accountability. It was a transparently weak excuse. They had taken my phone. The judge is having none of it. Notice how she immediately shuts that narrative down. She's not just a passive listener. She has read the file, she knows the players, and she sees the connections by saying, "Don't come in here playing as though you didn't know anything." The judge is sending a clear message: the time for games is over. She is piercing through the defendant's attempt to portray herself as a naive victim caught in circumstances beyond her control. This is a classic judicial maneuver to regain control of the narrative and force the defendant to confront the reality of their plea. The judge re-asks the question, this time with the premise of the crime baked right in. The pressure is on.
It's to find you guilty out of the court with deferred finding of guilt as you apply for deferred adjudication. Anything you want to say on behalf of your client?
Judge, just that we'd ask the court to file a plea bargain, and if the court pleases, we can waive a PSI this time.
So Ms. Schiaretti, what are you doing with your life other than inviting people under the pretext of having sex with them and then having them robbed? What are you doing with your life?
Those text messages weren't actually me. They had taken my phone and they're all 6'1" and I'm 5'1" and I couldn't jump up and grab it. I wasn't near my phone.
So do
But
you want a jury trial? Because see, right now, what is happening is sometimes people don't think that I've read things because I read quickly. So here's the thing. You are involved with all of these defendants. So don't come in here playing as though, oh my gosh, what? I didn't know anything. Somebody took my phone and started sending these text messages and these people just came over and then a robbery just happened. And I'm just here not knowing anything that's going on. So let's be honest, because you've already entered a plea to this. So other than luring people over with text messages for sex and then having them robbed, what are you doing with your life?
I want to get a GED, go to college.
Why do you need a GED? Why do you complete school?
Because I was getting bullied my sophomore year, moved away for a year to go to school.
Did you go
and
to
then I
school
had
while
to
you
move
were
back
away?
here. Yes. My junior year, I spent it in Illinois. Then I moved back here and
This is more than just a judge asking questions. This is a masterclass in deconstruction. The judge isn't buying the sob story about being bullied or her mom not being able to drive her to school. Instead, she's methodically taking apart the defendant's timeline and exposing the gaping holes in her logic. The analysis of the move to Illinois is particularly sharp. The judge presents two likely scenarios. Either her parents couldn't control her or there was a problem at home, and concludes that she was sent back for a reason. This isn't speculation. It's a logical deduction based on years of experience with similar cases. She's showing the defendant and everyone in the court that this isn't an isolated incident. It's a pattern of poor choices, instability, and a fundamental failure to take responsibility for her own life. Every excuse is being turned into another piece of evidence against her character.
didn't go back to school because I didn't want to go through what I went through my sophomore year. And
So you just came back here and did nothing?
I was gonna go to a different school, but my mom couldn't take me to and from at the time because she had work.
What is the
And I
via
was
bus
going
for?
to,
Why, see, this is the problem with society today. Everybody wants to have their own vehicle and drive to where they get to. We used to walk to school. Or guess what? You take the via bus. So if your mom can drop you off at school, you're old enough to get involved with the people in this to rob some people. So why can you take the via bus to get to school? Because right now, all I'm hearing from you are excuses. I couldn't go to school because I was bullied. So then I went to Illinois. And who did you go to Illinois with?
I was staying with my cousin.
All right, so there's a reason why you got sent back to San Antonio from Illinois. If things were going great in Illinois, you would have been in Illinois and you would complete.
I just hit it once. It's a line you hear all the time in court, and it almost never flies. The judge's skeptical response, "Nobody hits marijuana once," isn't just a witty comeback. It's a direct challenge to the defendant's credibility. After a long chain of unbelievable excuses about her education and employment, this admission, however minimized, is a critical moment. It confirms she's unemployed but still finding time and resources to use illegal substances with friends. It completely undermines her carefully constructed image as someone who is trying to get her life together. For the judge, this isn't about the marijuana itself, it's about the lie. It shows a continuing pattern of poor judgment and an unwillingness to be completely honest, even when facing a 5-year probation term that demands total compliance. This single unbelievable claim just cost her dearly.
Completed whatever you needed to complete it. What I've discovered in my time as a defense attorney and a prosecutor involved in CPS cases, when sometimes, and I would say about 60% of the time, when children leave their home to go live with their cousins in Illinois, one or two things are happening. Either the parents can no longer control them and they say, well, let's try a new setting. Now, I can't afford to go to Illinois, so I'm going to send you to Illinois with friends and family. Or either there's something wrong with the parents and they're like, I'm going to do my own thing. I don't want to be a parent, so I'm sending you to Illinois. Obviously, there was something happening in your home life where either you were not doing what you were supposed to do, which is attend school, and they sent you to Illinois for a change of scenery. Things were okay there for a while, but then something happened there. Either you were not doing what you were supposed to be doing, and they said, look, not our problem because not our child, we're sending her back to you to San Antonio. So all I've been hearing from you is what you're gonna do. But what have you been doing since this offense?
I was working, I had my own apartment,
Was working. Why are you not working?
because I got sick and I had to get out of work for 2 weeks and then I got sick again and my manager just didn't like that I got sick and I was out of work for 2 weeks.
So who are you living with?
Right now I'm living with my mom.
And what problems are you causing there?
No problems.
So are you seeking another job?
Yes, I'm currently looking for another job. I'm going to apply at Amazon with my aunt and see how that goes.
The hammer has just come down and the conditions are incredibly strict. A 5-year deferred adjudication, a $1,500 fine, 200 hours of community service, and a list of no contact orders. But the judge is going much, much further. A strict 6 p.m. curfew, mandatory full-time employment within 30 days, no jobs in home health care or with minors, and random field visits 3 times a month. This isn't a standard probation. This is a highly structured, heavily monitored sentence designed to leave zero room for error. The judge is essentially putting the defendant on a tight leash, controlling her schedule, her employment, and her associations. The goal is clear: to break the cycle of excuses and instability she's demonstrated. The defense attorney's question about the Amazon job highlights just how restrictive this curfew will be. The judge's answer is firm: the only exception is work, and she'll need proof.
Really likes it, so I feel like I'll like it. There's a couple other places that I have in mind.
And if you're drug tested today, what are the results going to be? And know that you are getting drug tested today. So if it's going to be positive or something, it will behoove you to tell me right now what it is. Yes, tell the truth and shame the devil. What will it be?
It might come out positive.
For
just
what?
for marijuana.
Who you've been using marijuana with? Because I'm hoping it hasn't been at your mom's home.
No, it's not.
So who have you been using marijuana with?
One of my friends had it and they asked me if I wanted it. I hit it once.
No, nobody hits marijuana once.
No, I did. I swear. I just hit it once.
So you're
And we're back. It appears some time has passed and Tony Reddy is in front of the same judge for a probation review. This is where the rubber meets the road. The judge laid down some of the strictest probation conditions you'll ever hear, from a 6 p.m. curfew to mandatory full-time employment. The big question is, has any of it worked? Has the harsh lecture and the threat of 20 years in prison finally gotten through to her? The judge starts with the same simple questions: what are you doing with your life? And what will a drug test show today? Based on her first appearance, the odds don't look good. But now we get to see the real-world results of the court's orders. Is this a story of a successful turnaround, or is she about to dig herself an even deeper hole?
out of work, but you do find time to have marijuana with friends. So that means that you are going to end up causing problems with your mom. I'm going to try to stop that and nip that in the bud. So how far did you go in school?
Senior year, that's when I didn't go.
Do you have any children?
No,
All right, any other questions from either side?
Nothing from the state, Your Honor.
Nothing, Judge.
All right, and you're going to be drug tested today, and so you're telling me it's only going to be marijuana?
yes, ma'am.
All right, I'm going to sentence you to 5 years deferred adjudication. There's a $1,500 fine. Time and money are going to run concurrent. There's going to be a UA, and I want her to be continually tested for levels, Ms. Reyes, and she's going to do a UA today.
Yes, ma'am.
And if she tests positive for anything other than marijuana, I want to know, and I want her back in court. There's going to be 200 hours of community service restitution. 40 of those hours will be waived if you provide proof of the COVID vaccination. The court is not requiring you to get the COVID vaccination, but if you do, 40 of those hours will be waived. You're gonna obtain your GED, full-time employment. And for the court, full-time employment is at least 8 hours a day. So if you need to get 2 part-time jobs and get your 8 hours, then that's what you're gonna have to do. There's to be no employment as a home health care provider or with minors. There's to be regular reporting by Zoom or in person. So if you can't report by Zoom, you're gonna have to report in person. I'm gonna want her to have a curfew, so you need to be in the house by 6 p.m. The only exceptions to being in the house by 6 p.m. is if you're at work. And she's only allowed to leave the house by 7 a.m. So 7 a.m. to 6 p.m. I'm gonna want field visits, random, 3 times per month. She's to reside with Janetta Sharette. Rebecca, is there anything else that she needs? Is there any restitution involved here?
I don't believe so, Judge.
All right, anything else she needs, Norma? I'm sorry, Rebecca.
No, Judge, but on the employment, you want her to have the employment within how many days?
Within 30 days.
Okay, that was it, Judge.
Thank you. Is there anything else you need from me in order to be successful?
Judge, in regard to the curfew, the Amazon job she's talking.
This is the moment the entire hearing has been building towards. The drug test results are in, and it's a bombshell. There were some faint lines for cocaine. While the probation officer is counting it as a negative, the judge has seized on it. This is a massive red flag. The defendant's denial is immediate and emotional, deflecting by bringing up her brother's addiction. But the judge isn't focused on the denial, she's connecting the dots. The defendant was recently found at her brother's girlfriend's apartment complex. The brother she just admitted is an addict. Suddenly, her presence there looks incredibly suspicious. This isn't just about a faint line on a test anymore. It's about a clear violation of the spirit, if not the letter, of her probation. She's associating with people and places that are directly linked to drug use. The judge's tone has shifted from stern to furious.
Talking about is it's a warehouse in San Marcos. There may be some problem with getting there and back as far as the curfew goes.
It's overnight as well. Because it's.
The only exception to your curfew is if you're at work.
Okay,
So you'll need to provide proof of that.
okay.
All right, we can go off the record. I don't know if you realize how dangerous what you did was. Number one, somebody could have been killed, in which case we'd be here for something different, maybe capital murder, who knows? Number two, when you send text messages to people, telling them or offering them sex, and they come over and expecting that, and it doesn't happen, but instead there's a robbery that's taking place, you know what could have happened then? Somebody could have killed you. And you know what everybody would have said? Oh, well, she came over here to rob somebody and she ends up getting killed. Your parents, I don't know your mom personally, but obviously she's trying to do something with you and help you with your life. You're making your life more difficult than it has to be. I always tell people, life is so simple. If you follow the rules, it will be fine. Now you've made your life exceptionally hard because this deferred adjudication is going to follow you around. Do you understand? All right, good luck to you.
The judge is now in full damage control mode. After the cocaine scare and the revelation about her addict brother, the court is tightening the screws even further. Notice the specific direct orders. She is explicitly forbidden from going to her brother's or his girlfriend's apartment. Contact is limited to the phone or her mother's supervised home. The probation officer then drops another bomb. The defendant's proof of employment is just screenshots of a schedule, not actual pay stubs. This suggests she might not even be getting paid yet, or worse, she's trying to mislead them. The judge is reinforcing every single condition and demanding verifiable proof, pay stubs, not just schedules. She's leaving absolutely no loopholes. The defendant is losing every ounce of trust and freedom she had. This is what it looks like when your second chance is hanging by a thread.
All right, what's going on with you? What's going on in your life?
With Tony Reddy's case left on a knife's edge, we pivot to a completely new defendant, Mr. Smith, and the difference is immediate. The first thing the judge does is call him out for chewing gum, but with a firm yet almost instructional tone. Nobody knows unless somebody tells them. It's a small moment, but it resets the entire atmosphere of the courtroom. We learn he's here for a 5-year early probation dismissal, something the state has already opposed twice. The judge isn't just going to grant it. She immediately orders a surprise drug test and a review of his social media, the very thing that got him in trouble in the first place. This is his one shot to prove he's a changed man, but he has to pass the judge's impromptu tests first. The stage is set for a story of genuine redemption or a final crushing disappointment.
I just started a new job.
Right.
Um,
Doing what?
I'm a server.
All right. And if you drug tested today, what are the results going to be?
It would come back negative.
All right. We're going to do a drug test. Okay.
Okay, I did one yesterday.
Okay.
Okay.
All right. So we're going to do a drug test. And then who is your brother's girlfriend?
Kaylee.
All right.
I don't know her last name.
So do you still live with your mom?
Yeah, I just had to move back in there,
All right.
like
So
in April.
you're saying you had to move back in?
Yeah, I had my own apartment and I had it with a roommate. And I was giving her $800 a month and been friends with her since freshman year. Found out she wasn't, all the bills, all the money I gave her a month never went towards the bill. So we were over $6,000 in her rent. And I had all the receipts on me paying her and everything, so they let me out of the lease early. And it was a big altercation. I had to call the cops because she got physical with me and I didn't. I told the cops, I was like, I'm on probation. I'm not gonna get physical with her and risk getting in trouble for that.
The first hurdles have been cleared. The drug test is negative, and his Facebook, once a source of incriminating evidence, is now clean. The state's concerns have been addressed. Now the floor belongs to the defendant, Mr. Smith. This is his moment to prove that his transformation is more than just good behavior. It's a fundamental change in character. He's not making excuses or blaming others. Instead, he's prepared a letter. This is a powerful strategic choice. It allows him to organize his thoughts, show premeditation, and deliver an emotional, articulate account of his journey. For a judge who just spent the day tearing apart flimsy excuses from the previous defendant, a well-reasoned, heartfelt statement could be exactly what she needs to see. Will this letter be the key that unlocks his freedom? Let's listen.
It's not worth it.
All right. You're going to do a UA today.
Okay.
And I know previously there was an issue with you, and this is from March 2024, where you return back positive for marijuana and they did progressive sanctions. So we're going to do a UA, and then we're going to tighten up your schedule with your curfew for being at home with your mother.
Okay.
So first thing, we're going to see what this UA, the results are.
Mhm.
And then we're going to come back and I'm going to give you instructions, but your curfew is going to get tightened up. Okay.
Thank you, Judge.
All right. Thank you. Okay. All right, Miss Schiaretti, come forward. All right, you're going to go back on your curfew. So she needs to be at her mom's home by 6 p.m. unless she's at work. You're going to be on curfew. You're going to need to be in your house by 6 p.m. every day unless you are at work. Do you understand? If you're not at your house at 6 p.m., what's going to end up happening is they're going to give me notification and a motion to revoke could be filed. You understand? So what is your work schedule?
I know this week, today's my last day off, or Wednesday, Thursday, we might close at 1. I'm not 100% sure on like the times yet. I'm still gonna
Oh.
This is like my first week.
You are going to send your work schedule to probation.
That was incredible. This letter is the polar opposite of everything we heard from Tony Reddy. Mr. Smith doesn't talk about what he's going to do. He details what he has done. He takes ownership of his mistakes, expresses remorse, and then provides a concrete list of his achievements, graduating from college with an associate's degree, building a career in the automotive industry, gaining certifications, paying his own bills, and finding strength in his faith. This is the exact blueprint for what a judge wants to see in a candidate for early termination. He demonstrated accountability, took concrete steps towards self-improvement, and built a stable, productive life. The judge is visibly proud of him. He didn't just serve his time, he used it to fundamentally change his trajectory. This is no longer about just following rules. It's about a complete and total life transformation.
And you're going to give that to your probation officer. If you are not at work, you need to be in your house by 6 p.m. Do you understand? If you're not in your house by 6 p.m., they will know and they're going to let me know. Do you understand? And they're telling me that you're testing some of those lines were faked. They're counted as negative, but there were some faint lines for cocaine. So I don't know what's happening with you, but
I confirm, Judge. My brother, in all honesty, my brother is an addict with that, and I see the way he is with it. I would never do it. I just see the way it breaks my heart to see.
all right, so here's the thing. You're not allowed to go to your brother's apartment, your brother's girlfriend's apartment. Do you understand? If you are going to visit with your brother.
And there it is. The probation officer's report confirms everything. No prior criminal history, maintained full-time employment while also earning a degree, no issues with field visits or his curfew, all financial obligations met, and consistently negative drug tests. This is a perfect record. The 2 diluted samples from years ago are now insignificant in the face of 5 years of flawless compliance. The judge's decision is now an easy one. In granting the early termination, she gives him one final crucial piece of advice. The discipline that got him through probation is the same discipline he'll need for the rest of his life, especially now that no one is looking over his shoulder. It's a powerful moment of trust where the court is officially recognizing his change and giving him back full control of his life.
It is to be by phone only or at your mother's house. Do you understand? Okay. All right. And you're not allowed to go to his girlfriend because it says here that you were at your brother's girlfriend's apartment complex at one point in time swimming.
Not her.
All right. You're not allowed to go to your brother's girlfriend's apartment complex. Do you understand? And you shouldn't be anywhere but in your house by 6 p.m. unless you're at work. Do you understand? And if we could continue with field visits.
Judge, one thing I would suggest, I was reviewing her proof that she provided to Officer Parker. And they're mostly like screenshots of her schedule. I would also, if it doesn't say anything like her name, it's just kind of the schedule. I would suggest making sure you're turning in your paycheck stuff. And if you get like direct deposit or something, just something that shows like you're working. And I just haven't gotten that yet. Because like I'm still kind of, I haven't gotten a paycheck from there yet because I think we just in the every 2 weeks we get a paycheck. I want to say it's like, yeah, and I would say because it's just screenshots, I would suggest make sure you're turning in like your actual like proof that you're getting paid. If that is part of it. Yes, you can take screenshots from the apps, and I know a lot of employers use the app these days. But just something that shows like a good. Yeah.
All right. So you understand what's expected? All right. Make sure you follow through. If there are any issues, you can always come back to the court. Okay. All right. Good luck to you. All right. Hello.
Judge.
Hi. You're chewing like a cow in the field. Why are you chewing gum up here?
I'm sorry. Give me a spit out.
I'm chewing it loud. That's okay. Nobody, you know, nobody knows unless somebody tells them.
Yes, ma'am.
So let me see here.
Judge, may I?
Mhm.
There was a status report for early dismissal and discharge
Mhm.
submitted back in November. at that time, Mr. Smith had not been on probation for 5 years yet.
Mhm.
And so you said to reapply at the 5-year term.
Mhm.
ADA Garahan also opposed the application at that time. He opposed it again.
Mhm.
After speaking with him, he indicates he's opposing it
Based
because
upon
of the,
offense.
yes, based on the offense. So we did resubmit last month
Mhm.
and it was denied again, but I spoke with you, Judge,
Mhm.
and kind of gave you the background on Mr. Smith. And you said to bring him in and you would like to speak with him.
All right, when you drug tested today, what are the results going to be?
I'll pass.
All right, so I want a UA today. He can go to felony drug court, see if they can give him a UA today. And then before we leave here, State,
Yes. This is not in here, but he's the one that I've been talking to.
before he leaves here today, because there are Facebook posts that were in the stipulations. What does your Facebook look like now?
I don't post anything on Facebook now.
All right, let's let them see if you have no objection. Let them see your Facebook page and let's see what's in it in the last time you posted.
That's fine.
All right, so we're gonna do that, do a UA, and then if all comes back clear, you're gonna tell me your story about how you changed and I'll make a decision on terminating you early.
Yes, yes,
And
ma'am.
thank you for dressing appropriately for court.
Oh, thank you.
Yeah,
Thank you.
all right. All right, so I see your smile. So everything went well?
Yes, Judge. Mr. Smith's UA was negative.
Hmm.
ADA Garrett through his Facebook, no concerns.
Okay, so tell me about yourself. What have you been doing? What are your plans?
Actually, I have a letter. Can I read it?
Mm-hmm. Okay.
Dear Honorable Judge Boyd, thank you for the opportunity to be on probation instead of time in prison. Over the course of being on probation for the last 5 years, I have learned to better my life and build a career for myself in the automotive industry. Through probation, I have learned self-control, discipline, and patience. I took things for granted and I made bad mistakes that hurt people. And I ask for your forgiveness and the forgiveness of those people. My time in the Bexar County Jail changed my life. The Lord saved me from death by putting me in the jail. That is what I believe. Through jail, I became connected with Cornerstone Church, which was the stepping stone into my faith today. The Lord motivated me to better my life. I went back to school and graduated from St. Philip's College with an associate degree of applied science in automotive technology in May of 2024. Since the beginning of school, I've worked at multiple automotive shops to gain experience and certifications. I currently work at Freedom Chevrolet, and I've been there since January of 2024. I have learned to live on my own, pay rent and utilities. I plan to go further with a relationship with God and Jesus. I have goals and dreams set for my life. I want to use my gift of working on cars to help people who need it. And I ask you humbly consider my request for early termination so that I may move past this part of my life and show my family that I have successfully changed and completed my term of probation. Thank you, Honorable Judge Boyd, for your time and listening to me. I give God all the glory for the change in my life, and I give Jesus all the credit for being where I am today. Thank you.
Thank you so much. I'm so proud of you. I'm glad you were able to turn your life around. And what I can tell you is normally, I'll do early termination, but you have to show me something. You have to show me that you've changed and that you won't be back here
Yes,
for anything, and that you're going to be a law-abiding citizen.
yes, Judge.
All right, probation, what has he completed?
Judge, I like to point out that he had no prior criminal history. He has maintained full-time employment as well as completing with his associate's degree. His field visits were completed. There were no issues during those field visits. There was an 11 p.m. curfew implemented upon being granted probation. He completed that with no issues. 200 community service hours were also completed. He's met all of his financial obligations, all of his UAs, with the exception of a couple of diluteds back in 2022. But all of his UAs have been negative, Judge.
And he was negative today.
He was negative today, Judge. We just think at this time, he is a good candidate for early termination.
All right. And there's no restitution, correct?
No, Judge.
All right. Well, congratulations. Here's the thing, don't go out celebrating everything that you needed, the discipline you needed to successfully complete this probation. You're still going to need that discipline in real life, because let me just tell you, you're not going to have a probation officer looking over your shoulder where you're saying, oh, if I do this, I'm going to get in trouble with probation. You're going to have to do that on your own. You understand?
Yes, Your Honor.
But what I can tell you, if there are any obstacles that come up in your way and you need some advice, if I'm here, you can still come back here and ask me, okay?
Thank you very much, Your Honor.
All right, your probation is terminated. Good luck.
Thank you so much, Your Honor. I appreciate it. And I want to say one thing, if I
Sure.
can, before I go. When I first was here, I don't know if you remember, it was in 2020. I sat in those seats over there, and it feels good today having my freedom and not having to go back to the Bexar County Jail or back to prison or in prison. And I thank you for giving me that chance of being out to see my family and to show my family that I can change. And when I was here, I told you at that time that I gave my life to God. And you had told me at that time, when I first got probation, that a lot of people, when they get out of the jail, they say they believe in God and they follow religion, but then they go right back. I wanted to prove everyone that thought that wrong. And I wanted to prove the people that thought I was going to go back to jail wrong. And so thank you.
All right, congratulations.
What a powerful conclusion. In the end, we saw two vastly different stories of justice and accountability. Tony Reddy, who started her hearing with excuses, continued to make poor choices, and ended up with an even stricter probation and the shadow of a potential cocaine-positive test looming over her. Her future is uncertain, hanging by the thinnest of threads. Then there was Mr. Smith. He walked in, took responsibility, and presented undeniable proof of his transformation, a degree, a career, and a heartfelt understanding of his past mistakes. He didn't just ask for a second chance, he earned it. His final emotional words to the court, showing his gratitude and proving the judge's initial skepticism wrong, was the perfect end to his journey. Two defendants, one courtroom, two profoundly different outcomes. What did you think of the judge's decision to grant Mr. Smith's early termination? Let us know in the comments and subscribe for more deep dives into the courtroom.